This week on the Lectures in History podcast, Tulane University professor Blake Gilpin examines three important Supreme Court cases from the Reconstruction era: the slaughterhouse cases, United States versus Cruikshank, and Plessy versus Ferguson. Professor Gilpin explains how those rulings weakened civil rights protections and laid the legal foundation for Jim Crow segregation, a system of state and local laws, racial separation, and discrimination against Black Americans for decades. More in a moment.
Alrighty, folks. Can everybody hear me all right? This room is insanely big. It looks like my class is very unpopular. I'm going to get started. Obviously, as I told you, we're filming for C-SPAN, so I don't know that changes anything. Earlier this week, I was telling you all about this absolute deluge of white supremacist violence that gripped the former Confederacy, but especially the state that we are in, Louisiana, after the Civil War. In particular, what I was telling you about, hopefully that you gathered from Tuesday's lecture, was about this trio of racial massacres that are really just sort of the high points in this sort of decade-plus long campaign of violence against Republicans and emancipated slaves. Those comprise the Colfax Massacre, the Coushatta Massacre, and the Battle of Liberty Place. All of those incidents and this campaign in general really serve to violently erode Black equality as part of an attempt to invalidate the racially progressive Republican Party and restore the white supremacist Democratic Party, both in Louisiana and across the former Confederacy. Needless to say, this is something I did not point out on Tuesday, these are not the same political parties as today. Though they share the names and some degree of lineage, those parties will literally flip affiliations during the civil rights movement in the 1960s, exactly because of the issues I was talking about on Tuesday, and I'll be going into more today. The purpose of today's lecture is to delve into this trio of Supreme Court decisions, one of which was a prosecution of the perpetrators of the Colfax Massacre that together helped to pause this experiment in interracial democracy that was begun by the 13th, 14th, and 15th Amendments. It paused that experiment for about 6 or 7 decades, depending on when you're starting this. So today, I'll be exploring the Supreme Court decisions in these three cases, in the Slaughterhouse case, in Cruikshank, and Plessy versus Ferguson, all of which are based on cases that took place here in Louisiana, but have particularly dire implications for the states of the former Confederacy, and really for the nation as a whole. One way to think about this era comes via the great Reconstruction historian Michael Perman. Perman basically tried to label the different phases of what he called a longer Reconstruction. Those are the three phases of the immediate postbellum period. Today's lecture is going to cover two of those: redemption. That's the period I was talking a little bit on Tuesday, that commonly refers to this decade where white Southerners tried to reclaim control of the South after federal intervention, as well as the period that he dubbed Restoration, which refers to the decades that white Southerners spent removing Black voters and creating Jim Crow segregation in all aspects of Southern life. And so it's somewhat coincidental, let's see if we can get this to go, that just one day after the Colfax Massacre, April 14th of 1873, the Supreme Court handed down the decision in the Slaughterhouse case. One contemporary newspaper called it one of the most significant decisions that has ever emanated from the Supreme Court. And like many of the cases you've heard about this semester that carry really incredible consequences, this one grew out of a seemingly inconsequential matter. Responding to multiple outbreaks of contagious disease, the Reconstruction government in Louisiana created a single slaughterhouse, that is to slaughter animals, downstream from New Orleans, which replaced several unsanitary ones that were operating in New Orleans. And this culminated in something called Louisiana's Slaughterhouse Act of March 8th of 1869. What was this law? It required white butchers, this was almost exclusively a white profession at the time, to bring their cattle and hogs to a single new facility. And the case arose over bitterness with this government oversight. So this raises these issues that we've been talking about for the entire semester, about these clashes between federalism and anti-federalism, between state control and local authority. Much like the federally backed Republican governments supported by newly emancipated and enfranchised blacks, the legitimacy of the Slaughterhouse Act was deliberately questioned by the old ruling class, not simply because of an issue with slaughtering animals, but in a bid to destabilize the control of government by blacks and Republicans. This culture of white supremacist opposition was really personified by this guy that you see on the screen, John A. Campbell. He's a former Supreme Court justice who, to his everlasting, for him, pride, to us, shame, voted affirmatively in the Dred Scott decision. Just to remind you, what did that decision say? It declared people of African descent beings of an inferior order, altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect. This is more Dred Scott. No Negro of the African race, he ruled, could ever claim the rights and privileges of citizenship in the United States. So this is the same treasonous man, and I'm calling him treasonous because he served for almost the entire Civil War as the Confederate Secretary of War, who is now taking his time to oppose a slaughterhouse. In this case, what Campbell said he was doing was to undermine the legitimacy of the new Reconstruction Constitution. That is the Constitution that was made by the 13th, 14th, and 15th Amendments. Campbell devised a particularly clever or diabolical way of doing this in that he was using the 14th Amendment itself, particularly the Privileges and Immunities Clause, against the state. So despite the Slaughterhouse Acts being a sanitary measure that was well within the purview of state control, what Campbell thought to do was to use the 14th Amendment against that state itself. Campbell and his clients tried to convince the Supreme Court that the act had only passed, that is the Slaughterhouse Act, because of bribery, and that it violated the state constitution of Louisiana because it was signed after the legislature adjourned. More crucially, what Campbell tried to do in this case was basically use states' rights or betray the states' rights mantra that had defined secession by using the 14th Amendment against the state's own action. In other words, like nearly all the cries by white Southerners over a century or more for states' rights, it really came down to the rights they liked and the rights that they didn't. The Supreme Court's decision here ended up not agreeing entirely with Campbell's logic here about the unconstitutionality of the new slaughterhouse, but the expansiveness of the decision in this case effectively crippled the 14th Amendment. So I'm going to read you a little from this decision. To fetter and degrade state governments by subjecting them to control of Congress was not the 14th Amendment's intent. This is according to the majority opinion in this case. The Supreme Court would not serve as a perpetual censor of state laws in cases that were using the 14th Amendment. The decision eviscerated the Privileges and Immunities Clause so effectively, explains the most revered historian of this period, that the clause ceased to have constitutional meaning. Thereafter, black Louisianans and black Southerners generally were deprived of a potential constitutional avenue for asserting claims for this expansion of their rights that had taken place in the first 5 years of Reconstruction. Campbell and his supporters had designed their appeal specifically in this way. They wanted a Supreme Court that would weakly interpret the Reconstruction Amendments and then effectively remove a deferential federal government from the ongoing struggle for the return of white control. It was unsurprising that white supremacists in Louisiana felt so emboldened that in August and September, following this case, the state witnessed two of the most significant acts of violence aimed at black disenfranchisement in the postbellum era, which I told you about on Tuesday, Coushatta Massacre and the Battle of Liberty Place. The ascendance of Louisiana's White League, which was less secret, it was better organized and more explicitly political in its aims, this explains the writer Nicholas Lemon, revealed that its purpose was to use extralegal violence to remove the Republican Party from power and then to disenfranchise black people. We have been preserving the ascendancy of white people by revolutionary methods. In other words, we have been stuffing ballot boxes, committing perjury, and here and there in the state carrying elections by fraud and violence, explained one particularly verbose white supremacist. Quite simply, what the White League was trying to do was to drive Republican office holders out of power, to disrupt Republican campaign activities, and to prevent black people from voting. All of these were to be accomplished by any means necessary. In Louisiana, where most of this, some of the most brutal terrorist violence in American history was taking place, white planters defended the violent tactics of white citizens. Former Confederates chose violence because white Republicans, particularly carpetbaggers, were simply trying to organize the freedmen element against the interests of white people. With such incendiary purposes in mind, white supremacists actually testified in Congress that blacks and whites who supported the Republican Party would be dealt with violently and promptly. And one of the most central problems facing both black and white Southerners during this time period was how the system was going to change based on what the North was doing. The Springfield Republican, this is an abolitionist newspaper, or formerly an abolitionist newspaper, that had previously stood by people like Frederick Douglass, wrote about the dilemma facing the nation as this violence increased. We must get rid of the Southern question. There is no chance or hope of healthy politics until we do get rid of it. So long as the war issues are capable of being warmed over from year to year and election to election, so long as the large section of this country is disturbed by violence and paralyzed by misgovernment, so long as white is arrayed against black, so long will our politics be feverish with this disease. And so there's this impression in the North that basically Reconstruction needs to be abandoned just so the country can move on. No matter what's happening, no matter what the outrages are, that is the perception that's starting to appear in the Northern press. The New York Times highlighted how tired Northerners were of Reconstruction. 10 years ago, the North was nearly united in a feeling of sympathy for the freedmen and in a determination to defend their rights. Now, not a few believe that the rights of the whites are those which have been infringed upon. And so you can see this as basically being a 180-degree change from just a few years earlier. Simply put, I think we lost that one. The reunification of the nation, the readmission of Confederate states into the Union was going to come at the cost of black freedom. That's really the equation that starts to be established in the early 1870s. The 1874 congressional elections took on enormous significance basically as a referendum on Reconstruction itself. It became the great takeover of Congress by the Democratic Party in the postbellum era. The Louisville Courier-Journal, a Democratic newspaper, ran headlines after the Democratic success in these elections, busted the radical machine gone to smash. The Democrats captured the House of Representatives, and they took a Republican majority of 110 to a Democratic majority of 60. That is a pretty drastic result. Democrats also won a small majority in the Senate, but the real rejection of Reconstruction in the North and in the nation as a whole came at the state and local level. Democrats won governor's offices in New York and Massachusetts. These are Republican strongholds. They also swept governor's office in 23 states and also won control of 23 state legislatures. A Nashville newspaper talked about the significance of this change. The recent election was not an election. It was a country coming to a halt and changing front. The whole scheme of Reconstruction stands before the country today a naked, confessed, stupendous failure. At once the most remarkable and most inexcusable failure in all of history. And really what the election of 1874 helped show is that the Republican Party was paying for their support of black rights and the idea of racial equality. This was the sort of cost that was rendered to them in this election. The tensions between life in the former Confederacy and the North's political abandonment became more and more severe. And when white paramilitary forces demanded the resignations, and this is what starts to happen across the former Confederacy, demanding resignations of black officials in Vicksburg, Mississippi following this 1874 election, several hundred black citizens marched at the behest of Republican Adelbert Ames. Whites who were reinforced by white liners coming over the state line from Louisiana opened fire on these marching black Mississippians, and for 10 days, open warfare raged around Vicksburg. At least 29 blacks were killed, many more wounded and terrorized, and white liners took control of Vicksburg government. This 1874 takeover of Vicksburg made Black 4th of July celebrations the following year all the more exceptional. That really a bold and courageous public gathering so soon after so many people had been killed. Black politicians speak in Vicksburg, a black Republican circuit court judge, the black Secretary of State from Mississippi, and as they finished, a mob of 50 white Mississippians burst into the convention hall and start firing. This should look very familiar from the incidents I was telling you about on Tuesday. They killed 2 attendees on the spot. They wounded another 10 who would later perish. All of this came at a peaceful 4th of July celebration. It's such a perfect symbol for what so offended former Confederates about black political agency and the sea changes that were taking place across the former Confederacy. In other words, black Southerners were not considered human. So the idea that they were performing publicly and politically is something that is deeply offensive to former Confederates. An account of this massacre actually appeared in northern newspapers in the New York Herald Tribune, which blamed not the white mob, but national reconciliation. So it's blaming the North partly for accepting this violence. The reporter said the killings on the 4th of July in Vicksburg occurred because Boston and Ohio were holding the coats for Georgia and Mississippi while they slay the common victim of Northern prejudice and Southern hate. Who was responsible for these black bodies? It wasn't just the mob. It wasn't just racist white Southerners. It was those people who were allowing the mob to continue to function in this way. The Colfax massacre actually produced a really rare example of an attempt at justice. That is a trial of 9 white men who were charged not with murder. That is a state judicial issue. They were charged with depriving murdered black Louisianans of their civil rights. And this is the jurisdictional quandary that I was trying to tell you a little bit about on Tuesday, which is that enforcing civil rights, enforcing the provisions of the Reconstruction Amendments, always had to confront this dilemma. Fair trials in state courts could not be guaranteed. And that was going to be for a very, very long time. Federal courts, at the very least, were supposed to follow the Constitution. After an initial mistrial, 4 of the 9 perpetrators of the violence in the Colfax massacre were actually convicted, which is pretty astonishing in and of itself, including this participant who is the name of this case, William B. Cruikshank. Cruikshank's conviction is then appealed. It rattles up the courts, and it ends up before the same Supreme Court that had crippled the 14th and 15th Amendments in the Slaughterhouse ruling. March 27th of 1876, Cruikshank and his 3 compatriots had their convictions overturned by the Supreme Court. This is not a good decision. Chief Justice Waite cited the Slaughterhouse cases in affirming state authority over its citizens, denied the 14th Amendment's ability to take such authority away from Louisiana. Sovereignty for the protection for the rights of life and personal liberty within the respective states rests alone with the states. That's what the Supreme Court decision says. The 14th Amendment prohibits the state from depriving any person of life, liberty, or property without due process of law, and from denying to any person within its jurisdiction the equal protection of the laws, but it adds nothing to the rights of one citizen as against another. The duty of protecting all its citizens in the enjoyment of an equality of rights was originally assumed by the states, and it still remains there. The only obligation resting upon the United States is to see that the states do not deny that right. This the amendment guarantees, but no more. The power of the national government is limited to the enforcement of this guarantee. This is a shattering decision to the ability of the federal government to actually enforce equality under the law. That is part of amendments to our very Constitution. James Beckwith, who is a U.S. attorney for the District of the Circuit Court of Louisiana, wrote to the U.S. Attorney General following the Cruikshank ruling, and he said, white terrorist organizations were proliferating following the decision. They had sprung to life, this is a quote, and grown influential precisely because of this decision.
C-SPAN's Lectures in History podcast continues in a moment. Now back to C-SPAN's Lectures in History podcast.
As one historian explains about the central fault in the logic of both the Slaughterhouse and Cruikshank cases, the state of Louisiana had, contrary to the Supreme Court's ruling, defaulted in their duty to protect their own citizens, so the federal government had to be called in. Indeed, the entire premise of this radical experiment in interracial democracy that was flowering for a brief moment during this time period was that Reconstruction rested on a pretty simple truth. The Confederacy had seceded entirely to continue enslaving black Americans, and in so doing, they had committed treason against the United States. Former Confederates, no matter what their rank, could not be trusted to adjudicate their own state's laws. And this was a reality that was going to take an entire 100 years, another century, of hard evidence to force Americans to revisit. I'll be telling you about that next week. The crucial distinction in the court's ruling in Cruikshank was that the federal government could only defend black rights if the state itself was the violator of those rights. The Cruikshank decision therefore gave a green light, wrote one historian, to acts of terror wherever local officials either could not or would not enforce the law. Adelbert Ames, who was a carpetbagger governor of Mississippi at this time, I mentioned a minute ago, he really captured the flavor of what the result of this decision was going to be, not just in Louisiana or Mississippi, but across the former Confederacy. Through the terror caused by murders and threats, the colored people are thoroughly intimidated. They are disenfranchised and are to be returned to a condition of serfdom, an era of second slavery. Really horrible prognostication for what was to come. If the election of 1874 was a referendum on Reconstruction, the election of 1876 was a referendum on finalizing redemption. That is, the return of the control of these state governments to white democratic power, and most of these people are former Confederates. 1876 was an absolutely brutal election in its rhetoric. We've talked about this before in the election of 1800 as well. But because the Grant administration actually had more than its fair share of scandals, and they were very real scandals, and also an economic depression that I do not have time to tell you about today, Republicans basically attempted to use really the only electoral tool they had at their disposal, which is this thing called waving the bloody shirt. What does that involve? It means bringing out aging Union generals. It means painting political opponents as Confederates, which they often were, secessionists or killers of Union soldiers. A guy named Colonel Robert Ingersoll, very famous orator who appeared at many Grand Army of the Republic, that's the Union Army organization, he captured this idea pretty well, and I'm just going to read you this quote from him. Every state that seceded from the United States was a democratic state. Every man that tried to destroy this nation was a Democrat. Every man that loved slavery more than liberty was a Democrat. The man that assassinated Abraham Lincoln was a Democrat. You get the feeling here. Every man that raised bloodhounds to pursue human beings was a Democrat. Soldiers, every scar you have got on your heroic bodies was given to you by a Democrat. And this is bloody shirt rhetoric. It's trying to basically tell voters to vote for Republicans because their opponents were the people who caused this terrible war. Bloody shirt rhetoric worked for a long time in American politics, and it really should have worked until the Confederate generation had died, or anyone who supported those ideas, this bedrock belief in racial inferiority, had moved off this mortal coil. But bloody shirt rhetoric ended up being pretty mild in the context of the election of 1876, and voting itself was the most violent election in American history. Hundreds and thousands of black voters, especially across Florida, Louisiana, Mississippi, and South Carolina, were physically intimidated in the ways that I talked about on Tuesday, and physically kept from voting. Only Louisiana, South Carolina, and Florida remained under really, really shaky Republican governments, and they also voted for the Republican presidential candidate. It was a guy named Rutherford B. Hayes. Samuel Tilden, who's the Democratic candidate, won 4 northern states, New York, New Jersey, Connecticut, and Indiana, which really is an indication of how weary Northerners were of continuing Reconstruction or federal oversight of this problem. Tilden won, and I'm putting that in scare quotes very purposefully, he won the popular vote. But neither candidate reached the threshold of 185 electoral votes for election. One of the best ways to think about this election, this is one of the lines my advisor used to use, was that the Democrats stole this election, that is by voter fraud and intimidation, and then Republicans stole it back. But I would add an addendum to this, which is that Democrats really ended up winning because of the Compromise of 1877, which I'll tell you about right now. This gets into a lot of political weeds, but the 12th Amendment explains that if there is a disputed election, the House of Representatives shall choose the president. But the great degree of ambiguity in these electoral results, particularly because of voter intimidation in the former Confederacy, meant that Southern efforts at violence and terror had basically propelled the same people who had committed treason in 1861 back into political power, and indeed to the precipice of the presidency itself. Southern newspapers like the Atlanta Constitution printed absurd stories where they talked about local militias in the North preparing to march into the South again. Civil War is coming. Northern papers like the Chicago Tribune printed similar articles, slightly more accurate, about Confederate mobs and militias that were drilling across the South to invade the North. The U.S. House of Representatives then had to decide in the context of this incredibly paranoid and violent situation how to decide the outcome of this election. 15 members on an electoral commission. What do? They put 5 Republicans, they put 5 Democrats, and 5 Supreme Court justices. Those 5 Supreme Court justices break down into 3 Republicans and 2 Democrats. How do you think the Electoral Commission votes? 8 Republicans vote that Hayes wins, and 7 vote that Tilden had won. Democrats in Congress begin a 3-month filibuster, so nothing can take place. The slogan among Democrats at this time is Tilden or fight. Not exactly a great message in the wake of this incredibly bloody Civil War from a decade earlier. The president is in no position to do anything about this because all he wants is to get out of office as soon as possible. He has already booked his ticket, and I mean literally booked his ticket for a world tour following the election of the new president. But what does Grant begin to do? This should show you how bad things are. He quietly begins to re-garrison and rebuild forts around Washington, D.C. There is a very real fear of civil war breaking out in 1877 because of all of this controversy. As I mentioned, the commission votes that Hayes had won based on this sort of understanding that there was widespread fraud and violence in all of the states of the former Confederacy, but particularly in these 3 disputed states of Louisiana, South Carolina, and Florida. The disputed election is actually settled in this place. This is a hotel in Washington called the Wormley Hotel, a perfect name for this event, where in the back room of the Wormley in 2 days in February of 1877, political representatives that aren't necessarily the most important politicians, 5 Ohio Republicans representing Hayes and 4 Southern Democrats representing Tilden, hammer out the details of how this election is going to be settled. This is a backroom bargain made over the body of the emancipated slaves. The Democrats are willing to give up the presidency if they could get what they wanted in return. So what did they want? They wanted federal subsidies. In some of these cases for Western Pacific Railroad terminus, they wanted their harbors dredged by the federal government. They wanted federal subsidies to rebuild the infrastructure of the South. Lo and behold, they wanted federal money. All of these states' rights, Southern Democrats, most of them former Confederates, wanted the guarantee of federal support to rebuild their society. And central to what the Democrats were willing to give up, the presidency, they wanted the return of what they called home rule. Home rule is the political control by white Southerners of the former states in the Confederacy. Specifically in the compromise, that's Louisiana, South Carolina, and Florida. Republicans agreed to this, to let Southern Democrats take over those 3 states, abandoning their own party leaders and abandoning a lot of black elected officials who were still running those governments. Finally, in exchange for letting the likely actual victor, Hayes had most likely won this election even without the fraud. Republicans agreed to the most severe rollback of the Reconstruction era, which was to remove all federal troops from the South. This is a huge symbolic gesture, and Ulysses S. Grant quietly signs this bill that repeals the law placing those troops in the South. What did Democrats agree to? Obviously, they agreed to let Hayes be president. They also agreed, I'm putting that in scare quotes too, to enforce the Civil War amendments and to protect black civil rights. Obviously, they have no commitment to actually doing this. Hayes is inaugurated privately on March 3rd of 1877 because officials are afraid there is going to be violence in D.C. if he is given a normal public inauguration. And Hayes follows the spirit of this disastrous election and the late attitude of Reconstruction. The South is going to be essentially permitted to retake control of its social institutions, its political life, and treatment of its people. And this is when some of the worst apathy and negative histories of Reconstruction start to begin to be written. This is probably the most misunderstood period in American history. President Grant goes on record declaring Reconstruction dead. But the devastating corollary to this is that Reconstruction should not have been attempted. This is Grant himself telling his cabinet that the 15th Amendment had done the Negro no good. The Negro, one early commentator explained, will disappear now from the field of national politics. Henceforth, the nation as a nation will have nothing more to do with him. The decades that followed the Compromise of 1877 were not pretty ones for black civil rights, for the legacy of the Civil War, or especially for the legislative and political achievements that had taken place in Reconstruction. Universal male suffrage, that is enshrined in the 15th Amendment, had enfranchised about 1 million black Americans, most of them former slaves. Voting rights were guaranteed by the federal government under the 15th Amendment, as were civil rights under the 14th Amendment. But enforcement of those amendments would prove, it still proves, enormously complicated. Indeed, abandoning those fights, which is what the North is essentially doing bit by bit in the 1870s, continues to show how black civil rights are a very easy concession in times of disappearing commitment. It's something that's easy to let go of by former partners. Alongside the violence that is still gripping the South in 1877, the Southern political elite reconstitutes itself, reorganizes in the Democratic Party. And following the return of home rule, this is kind of the main substance of the Compromise of 1877, white Southerners seek to restore the antebellum status quo. That is, they want to bring life back to the way it was in 1860. They want it as close to slavery as they can get in every possible way. They want to remove all traces, this is under what is called restoration, of the political and electoral system that was created during the previous decade during this radical experiment in interracial democracy. For 15 to 20 years after redemption, Democrats certainly acknowledge the continuing existence of this electoral system that was established during Reconstruction, but they went to much greater legal efforts. So you can think about the previous two periods being defined by illegal, terrorist violence and intimidation and voter fraud. But what happens in this final phase is really trying to use the law to exclude these people from the body politic. White Southerners never accepted the world that had been created by Reconstruction amendments. They did not accord it legitimacy, and just as they never sanctioned the governments that had been created under it. Instead, what white Southerners did, especially during this final phase, was to manipulate and subvert that system without actually eliminating it. They didn't make their challenges so big that the Supreme Court would come in and meddle with what they had done. They were basically following the system that had been set up under Slaughterhouse and Cruikshank, which is that the federal government and the Supreme Court basically just wanted to leave the South alone. They were going to use that opening to do as much as they could. Viewed from the turn of the century, the 20 years, 1880 to 1900, located between Reconstruction and disenfranchisement or restoration, comprised the final of these three discrete periods about reclaiming the South by white Southerners. Part of the reason for this is actually the well-meaning efforts of people like Abraham Lincoln or even the radical Republicans. States in the former Confederacy had rewritten their constitutions under the immediate effects of military defeat and federal intervention. And so in one of the many unintended consequences of this process, Reconstruction constitutions actually gave Southerners the mindset that they could simply just write a new constitution if they didn't like the old one. And so the solution that they strike upon, let's see if we can get this to go, was to remove the black vote. That becomes the central campaign of these years. Restore the electorate to its pre-Reconstruction form and composition. In other words, white Southern Democrats embarked on disenfranchisement as a campaign to restore racial hierarchy and the rules of slavery. Phase one in this process was to use methods employed to overthrow Reconstruction governments, violence, and fraud. That's what I was telling you mostly about on Tuesday. Phase two, Democrats were using a variety of means to limit black voting and keep the Republican Party at bay. Violence was continuing, but the Democratic Party was starting to focus their efforts on the electoral system. That is, employing gerrymandering of election districts, rigging balloting, controlling the supervision of elections, and also engaging in outright fraud at the ballot box. White Southerners added legislation and fraud to force to slowly disappear the black vote. The third phase, which encompasses probably the most important judicial decision of the 19th century, can we make that claim, other than Dred Scott, which is Plessy. By the 1890s, which is when this third phase begins, there is the termination of equal rights in law as well as in fact or as well as in practice. The era of disenfranchisement by state laws began, and by 1901, the undoing of Reconstruction was essentially accomplished. So instead of manipulating and undermining the Reconstruction system, as Democrats had done in the second phase, white Southerners simply proposed to undo it and work within the laws that they started to create to eliminate black voters from this situation. That situation is much more complicated than it would at first appear, in spite of all this violence. By 1888, voter rolls in this state, to give one example, were still a nightmare for white elites. 128,150 blacks were registered to vote in the state of Louisiana. 125,407 whites were registered to vote. You had a black majority electorate, even in 1888, in the state of Louisiana. And this is the problem that white Southerners are seeking to undo by whatever means they have at their disposal. By its mere existence, the black vote is a danger. It's a constant threat. The presence of this pervasive, it's mesmerizing to white supremacists. As the New Orleans Daily Picayune phrased it, it is an incubus that haunted the state like a black specter, a grim nightmare. And I love how well this cartoon, which is from a North Carolina newspaper, corresponds to what is going on in Louisiana. It is the entirety of the former Confederacy that fears black enfranchisement, that fears the changes it is going to bring, that fears the kind of system it helps create. Louisiana's governor, Murphy Foster, admitted that as long as unrestricted suffrage makes the ignorant Negro a possible controlling factor in elections, he is a menace to honest elections and good government. Possessing no formal political power, that's gone, controlling no government institutions or positions anymore, black Louisianans in this case, merely as eligible voters, were still believed to dominate political life by their sheer numbers. This culminated in the election of 1896, which I'll be telling you a little bit about, but that election only was achieved, white political success in Louisiana's election of 1896, by massive electoral fraud on the part of Democrats. It was already clear that white Democratic power structure needed to dispose of these 128,000 voters, regardless of legality. And the very mechanism that they started to do that was by using state power, state laws, to counter federal laws and the Constitution. During the 1890s, what each state in the former Confederacy did was set in motion complicated and hazardous electoral movements aimed at removing large numbers of their own voters. These are ruthless acts of political surgery, creating constitutional conventions to create new constitutions, to create a state, not a federal, legal apparatus that will violate the Reconstruction Amendments. But we've clearly seen in these Reconstruction-era cases that the Supreme Court doesn't want to do anything intervening in state matters. The Restorationist movement, which you could probably call Make the South the Antebellum South again, helped ease the political and social turbulence of sectional conflict and its aftermath to create stability and calm during the first half of the 20th century. All of this is achieved at the cost of black civil rights. Internally, those movements see a shift, as I've been talking about, from terrorist violence to intimidate voters to legislative voter disenfranchisement. That's going to define the 20th century American South. The introduction of poll taxes, of grandfather clauses, literacy tests to prevent blacks from voting, combined with the effects of the Plessy ruling, which I'm about to tell you about, are going to introduce nearly 7 decades of what is probably the nadir of racial equality and equal justice in the history of the United States. Black Americans and their allies are not ignorant of all of this developing scaffolding that's going to prevent equal justice under the law, and they start to pursue efforts to preserve the gains of Reconstruction, culminating with the Plessy case in the 1890s.
C-SPAN's Lectures in History podcast continues in a moment. Now back to C-SPAN's Lectures in History podcast.
Along with Dred Scott versus Sanford in 1857, Brown v. Board of Education, which I'll tell you about next week in 1954, Plessy versus Ferguson is one of the 3 watershed American civil rights cases. It can also really be understood, as I've tried to tell you today, alongside the other Reconstruction Louisiana cases, that is Slaughterhouse and Cruikshank, as a trio of Supreme Court decisions that will effectively cripple Reconstruction amendments for nearly a century. In 1890, among its efforts to restore social white supremacy, the Louisiana legislature passed the Separate Car Act, which required black and white passengers to ride in separate railroad cars. In 1891, 18 New Orleans residents formed the Comité de Citoyens, a citizens committee, to challenge the constitutionality of that act. What does this committee do? They raise funds, they hold rallies, they hire attorneys, and they try to find a person to be their test case against the Separate Car Act. This is the inauguration of a method that will be used for the next century and beyond. A perfect subject to challenge a law becomes a real effective strategy to do this. Under guidance from the committee, the first person they choose is a musician named Daniel Desdunes of the Creole Onward Brass Band. He volunteers to defy the Separate Car Act on February 24th of 1892. I'm telling you about him because they don't always choose right the first time. And it doesn't always go the way a test case, the designers of it want it to go. Desdunes boards a designated whites-only car on the Louisiana and Nashville Railroad from New Orleans to Mobile, Alabama. The committee chose to test the law specifically on that route because they thought crossing state lines would provide a constitutional basis of violation under the Commerce Clause of the U.S. Constitution. Desdunes is ordered off the chain. He is arrested. Soon after his arrest, the Louisiana Supreme Court ruled in a separate case called Abbott versus Hicks that the Separate Car Act did not apply to interstate passengers. So basically, this first run doesn't work, and so they choose this guy named Homer Plessy, who is a shoemaker born to free people of color in 1863, and he volunteered to be the next test case, June 7th, 1892. He arrives at the Press Street Railroad yards in New Orleans. You can go see this today. He purchases a first-class ticket on the East Louisiana Railroad bound for Covington, and he took his seat in a whites-only car. When he was asked to leave, he refused and is arrested for violating the Separate Car Act. What those actions set in motion is for the courts to decide if the Separate Car Act could be applied to travel solely within the state of Louisiana. Plessy appeared before a judge, John Howard Ferguson, on October 13th of 1892 in State of Louisiana versus Homer Adolph Plessy. He pleaded not guilty to the charges of violating the Separate Car Act. And on October 28th, Plessy's lawyer, a guy named James Walker, argued that the Separate Car Act violated the 14th Amendment, which guaranteed due process and equal protection under the law. Judge Ferguson ruled against him on November 18th of 1892. There is no pretense that Plessy was not provided with equal accommodations with the white passengers. He was simply deprived of the liberty of doing as he pleased and of violating a penal statute with impunity. In December of 1892, the Louisiana State Supreme Court, presided over by a former Confederate officer, this is the nature of the postbellum South, upheld Ferguson's decision. In April of 1896, Plessy's legal team was able to bring his case before the U.S. Supreme Court. Plessy versus Ferguson, the lead attorney was this guy named Albion Winnegar Torget, one of the most famous judges during the Reconstruction era, racial progressive, who argued that segregation's primary effect is to perpetuate the stigma of color to make the curse immortal, incurable, inevitable. The Supreme Court issued its ruling in this case on May 18th of 1896, voting 7-1 to uphold Louisiana's court decision. We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. That is Justice Henry B. Brown, writing for the majority of the Supreme Court. If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it. So it's black people's fault that separate but equal isn't equal. It's just in their minds. If one race be inferior to the other socially, Judge Brown wrote, the Constitution of the United States cannot put them upon the same plane. Brown's reasoning is the bedrock of white supremacy before and after black suffrage, affirming the invented differences of race and the inability of the law to promote actual equality. A law which implies merely a legal distinction between the white and colored races, a distinction which is founded in the color of the two races and which must always exist so long as white men are distinguished from the other race by color, has no tendency to destroy the legal equality of those two races. The object of the 14th Amendment was undoubtedly to enforce the absolute equality of the two races before the law, but in the nature of things, it could not have been intended to abolish distinctions based upon color or to enforce social as distinguished from political equality or a commingling of the two races upon terms unsatisfactory to either. This is a devastating decision, so much in the mold of the Dred Scott decision, it's kind of hard to overstate. This case is notable, probably more than almost any I can think of, for the eloquence and importance of its dissenting opinion, which it was written by John Marshall Harlan, the lone dissenting justice in this case, forever a black mark upon our judiciary. The destinies of the two races in this country are indissolubly linked together, and the interests of both require that the common government of all shall not permit the seeds of race hate to be planted under the sanction of law. What an amazing phrase that is. The thin disguise of equal accommodations for passengers in railroad coaches will not mislead anyone nor atone for the wrong this day done. The judgment this day rendered will in time prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. I would say he's underselling it, because what the decision in Plessy helps create is a system that will reign until the civil rights movement starts to legally undo it. That is a legally enforced and sanctioned, as Harlan is pointing out, system of legalized black inferiority under the aegis of separate but equal. What effect does this have? In Plessy, what the Supreme Court does is legitimize racial segregation on railroad trains. It provides the legal foundation for all the Jim Crow laws that will be written in those southern states that don't have to worry about being intervened upon by the Supreme Court. That decision restores the legal barriers between black and white people that had fallen because of the Civil War. Segregation takes hold of American culture, then spread blood deep into every crevice. Terrorism, giving rise to murder with impunity by civilians as well as law enforcement officials. Plessy heralded a disastrous period for those who believed in American democracy. Every aspect of American life was affected by this ruling, writes Gloria Brown Marshall in her History of the Battle Over Voting Rights. The states were given the power to legislate social interaction between the races. The Plessy versus Ferguson opinion instituted separate but equal doctrine, which imposed on this country an Americanized version of apartheid. January 11th of 1897, Plessy returned to criminal court in New Orleans, entered a guilty plea, paid a $25 fine. After the Supreme Court's decision, the Comité de Citoyens continued to maintain that segregation was unfair and unconstitutional, but the case set this legal precedent that would loom until Brown v. Board starts to undo this machinery. Louisiana and other states start passing segregation laws. They are confident that the federal government would defer to them. This is why this federalist and anti-federalist stuff remains so important. Separate but equal remains official doctrine until its overturning in the 1954 decision that I'll tell you about next week. Even in the dawning age of Jim Crow that the Plessy decision so dramatically illustrated and aided, Louisiana and a few other states proved exceptionally challenging to those wanting to eliminate black political voices. In 1896, just to give you an idea of how crazy this is, black citizens still made up 45% of registered voters in the state of Louisiana. That is a number that has never been equaled since. In other words, despite all this terrorist violence, its success in driving out the federal government, its success in intimidating the Supreme Court, in intimidating voters, in altering the results of specific elections, black Louisianans remained totally dedicated to trying to effect change politically. This is a process that is well discussed in Southern newspapers and agricultural and political journals, filled with discussions of how to get rid of black voters. Indeed, by the late 1880s, efforts proceeded across the states in the former Confederacy to consolidate power among white Democratic minorities. In 1889, Florida was the first to pass a poll tax law to prevent black people from voting. In 1890, Mississippi creates this thing called the Mississippi Plan, which creates laws including poll taxes and literacy tests to prevent black people from voting. South Carolina, Louisiana, North Carolina, Alabama, Virginia, Georgia, and Oklahoma all passed similar taxes, poll taxes, grandfather clauses, literacy tests to voting registration requirements based on the Mississippi Plan. In May of 1894, what Louisiana does is try to rewrite their constitution. And they hold a constitutional commission to draft a suffrage amendment that would establish a series of qualifications designed to disenfranchise black voters, including residency requirements, poll taxes, and either a literacy test or high bar of property ownership to do that. The state legislature was also simultaneously trying to do something called a secret ballot, which basically eliminates the possibility of black elected officials. White supremacist Democrats in the state hadn't figured this out, and basically the 1890s are just this ongoing experiment of how to remove black voters from the body politic. The 1896 election is probably the most fraudulent in this state's history. The white supremacist gubernatorial candidate, a guy named Murphy Foster, somehow won in 25 black majority parishes. There is a formal protest to these electoral results, calling them so false and so infamous that they would require a complete audit of the ballot. The premier historian of voter disenfranchisement in the South explains that as the ink on the forged ballots was drying, the Picayune announced the lesson to be derived from the recent election: the illiterate and shiftless population, chiefly but not wholly made up of the Negro element, should be expunged. And there is a political crisis that grows out of the fraudulent 1896 election that causes Louisiana's Democratic leadership, a guy named J.C. Pugh, Ernest B. Crutchton, who I'll tell you about in a second, and Robert S. Landry, to publish something called The Address to White Democracy, in which they describe the only three possibilities for Louisiana if black voters were not removed. Amalgamation, that is the intermixing of races. This is their words. Amalgamation, Negro domination, or white supremacy, which they put all in caps. The democracy is pledged to a limitation upon suffrage which will eliminate the Senegambian from politics as far as can be under the Constitution of the United States. That was the explanation of Louisiana's Democratic Party leaders. Mississippi and South Carolina have set us the example. Louisiana pioneered the grandfather clause, all manner of disenfranchising strategies, and what happened over the next 6 decades was essentially the elimination of black voters. Although the 30 years following black enfranchisement in Louisiana were covered with examples of violence and struggle, black voter registration was actually at its highest in the history of the state in 1896. The following 70 years would show how effective the legislative phase of this would be in eliminating black voters from the body politic. When one form of voting discrimination was identified and prohibited, one congressional report explained, another sprang up in its place. States like Louisiana interpreted the Plessy ruling as a legal mandate to develop sophisticated and persistent methods to disenfranchise black voters, but perhaps just as importantly, to create a cultural, economic, and political structure that announced it was proud of its white supremacy, and it drove home the message of black inferiority. The next few decades showed Louisiana's unremitting and ingenious methods of ensuring that black people would have no effect on the political process and would return to second-class citizenship. The 1896 election drove the Louisiana Democratic Party to embrace, most centrally, the grandfather clause. Other voter qualification strategies originally devised in the 1894 Constitutional Convention. So in 1898, when 44% of the electorate was black, Louisiana pioneers imposing these Byzantine education and property requirements on any citizen whose fathers or grandfathers had not been registered voters before January 1st of 1867. That's what the grandfather clause is. It is an impossibility for any black Louisianan to have a relative that was a voter before 1867 because there were no black voters. Black voting numbers plummeted from 130,334 to 5,320. So from 45% of the electorate to 4% in 2 years. Grandfather clause is the primary driver. The black vote would be suppressed. It would not exceed 1% of the state's population for decades. Indeed, not entirely clear which of these strategies was responsible for this. Researchers have been unsuccessful in locating a single elected black official in Louisiana until the 1940s. This guy I was just mentioning, Ernest Crutchnet, president of the 1898 Constitutional Convention, explained disenfranchisement as the exact design of the grandfather clause. We know that this convention has been called together, he explained, to eliminate from the electorate the mass of corrupt and illiterate voters who have during the last quarter of a century degraded our politics. Doesn't it let the white man vote? And doesn't it stop the Negro from voting? And isn't that what we came here for? Indeed, contemporary observers understood that white politicians were simply attempting to perpetuate the final big steal in Louisiana so that there would be no more need for terrorist violence or fraudulent work at election time. In other words, white Louisianans were legalizing the exclusion of black voters so that resorting to illegal electoral strategies, voter intimidation, ballot stuffing, ballot destruction, all of those would become unnecessary. And in response to the baldness of the disenfranchising effort in Louisiana, the U.S. Supreme Court eventually had to step in. They did so, eliminating the grandfather clause in 1915. That's a case called Gwynn versus United States. But Louisiana basically just came up with other ways of doing this. All in search of Crutchnet's statement about stopping the Negro from voting. This is all not directly related to Plessy, except in the world that it helps create. That is, the Jim Crow South, that is the product of Plessy's ruling, is probably the most horrible chapter in our nation's history. I'm sure you're familiar with these images of separate water fountains and separate restaurants. But really, I think the greater legacy of Jim Crow are the laws that are put on the books during these 8 decades that are designed to keep black people in an inferior position, to restore a system of relations between white and black people that existed before the Civil War. I'll post all this stuff. I don't have time to read it all. But as you can see, we're talking about laws regarding education, very, very hard to undo. Laws regarding entertainment. Laws regarding freedom of speech. We're talking about direct assaults on the U.S. Constitution made under the safety of the Slaughterhouse, Cruikshank, and Plessy decisions. That is, the South knows, or at least is willing to risk, that the Supreme Court will not intervene in these efforts to keep blacks as second-class citizens. Finally, marriage, one of the most notable and first to fall in this process. The fight against these injustices, the belief system that underwrote them, is one of the most inspiring stories to me in our nation's history. It's not just, oh, this was so bad. It's that the people who tried to fight against it, not beginning with Homer Plessy, but he's one of them, is really one of the most inspiring stories that we can learn about as Americans. I'll tell you more about this next week when we talk about Brown v. Board and the Voting Rights Act, which are two of the most explicit consequences of the Reconstruction amendments and the efforts to basically evade their enduring promise. That is, Brown v. Board and the Voting Rights Act are attempts to actually deliver on the promises made during Reconstruction that failed so spectacularly when the white South decided to keep fighting back. I'll continue that story next week. Thanks for coming, guys, and I will see you soon.
Thanks for listening to this week's Lectures in History podcast. To find more of our history programming, visit our website at c-span.org.